A copy of Justinian's Pandix, being newly discovered at Amalfi, soon brought the civil law into vogue all over the west of Europe, where before it was quite laid aside and in a manner forgotten, though some traces of its authority remained in Italy and in the eastern provinces of the empire. This now became in a particular manner the favorite of the popish clergy, who borrowed the method and many of the maxims of their canon law from the original. The study of it was introduced into several universities abroad, particularly that of Bologna, where exercises were performed, lectures read, and degrees conferred in this faculty, as in other branches of science. And many nations on the continent, just then beginning to recover from the convulsions consequent upon the overthrow of the Roman Empire, and settling by degrees into peaceable forms of government, adopted the civil law, being the best written system then extant, as the basis of their several constitutions, blending and interweaving it among their own feudal customs, in some places with a more extensive, in others a more confined authority. Nor was it long before the prevailing mode of the times reached England. For Theobald, a Norman abbot, being elected to the see of Canterbury, and extremely addicted to this new study, brought over with him in his retinue many learned proficients therein, and among the rest Roger surnamed Vicarius, whom he placed in the University of Oxford, to teach it to the people of this country. But it did not meet with the same easy reception in England, where a mild and rational system of laws had been long established, as it did upon the continent, and, though the monkish clergy, devoted to the will of a foreign primate, received it with eagerness and zeal, yet the laity, who were more interested to preserve the old constitution, and had already severely felt the effect of many Norman innovations, continued wedded to the use of the common law. King Stephen immediately published a proclamation, forbidding the study of the laws, then newly imported from Italy, which was treated by the monks as a piece of impiety, and, though it might prevent the introduction of the civil law process into our courts of justice, yet did not hinder the clergy from reading and teaching it in their own schools and monasteries. From this time the nation seems to have been divided into two parties, the bishops and clergy, many of them foreigners, who applied themselves wholly to the study of the civil and canon laws, which now came to be inseparably interwoven with each other, and the nobility and laity, who adhered with equal pertinacy to the old common law, both of them reciprocally jealous of what they were unacquainted with, and neither of them perhaps allowing the opposite system that real merit which is abundantly to be found in each. This appears on the one hand from the spleen with which the monastic writers speak of our municipal laws upon all occasions, and, on the other, from the firm temper which the nobility shewed at the famous Parliament of Merton, when the prelates endeavoured to procure an act, to declare all bastards legitimate in case the parents intermarried at any time afterwards, alleging this only reason, because Holy Church, that is, the canon law, declared such children legitimate. But all the earls and barons, says the Parliament roll, with one voice answered that they would not change the laws of England, which had hitherto been used and approved. And we find the same jealousy prevailing above a century afterwards, when the nobility declared with a kind of prophetic spirit that the realm of England hath never been unto this hour, neither by consent of our Lord the King and the Lords of Parliament shall it ever be, ruled or governed by the civil law. And of this temper between the clergy and laity many more instances might be given. While things were in this situation, the clergy, finding it impossible to root out the municipal law, began to withdraw themselves by degrees from the temporal courts, and to that end, very early in the reign of King Henry III, episcopal constitutions were published, forbidding all ecclesiastics to appear as advocates in foro faeculari, nor did they long continue to act as judges there, nor caring to take the oath of office which was then found necessary to be administered, that it should in all things determine according to the law and custom of this realm, though they still kept possession of the high office of chancellor, an office then of little judicial power, and afterwards, as its business increased by degrees, they modelled the process of the court at their own discretion. But whenever they retired, and whenever their authority extended, they carried with them the same zeal to introduce the rules of the civil in exclusion of the municipal law. This appears in particular manner from the spiritual courts of all denominations, from the chancellor's courts in both our universities, and from the high court of chancery before mentioned, in all of which the proceedings are to this day in a course much conformed to the civil law, for which no tolerable reason can be assigned, unless that these courts were all under the immediate direction of the popish ecclesiastics, among whom it was a point of religion to exclude the municipal law. Pope Innocent IV having forbidden the very reading of it by the clergy, because its decisions were not founded on the imperial constitutions, but merely on the customs of the laity. And if it be considered that our universities began about that period to receive their present form of scholastic discipline, that they were then, and continued to be, till the time of the Reformation, entirely under the influence of the popish clergy, Sir John Mason, the first Protestant, being also the first lay Chancellor of Oxford. This will lead us to perceive the reason why the study of the Roman laws was in those days of bigotry pursued with such alacrity in these seats of learning, and why the common law was entirely despised, and esteemed little better than heretical. And, since the Reformation, many causes have conspired to prevent its becoming a part of academical education, as, first, long usage and established custom, which, as in everything else, so especially in the forms of scholastic exercise, have justly great weight and authority. Secondly, the great intrinsic merit of the civil law, considered upon the footing of reason and not of obligation, which was well known to the instructors of our youth, and their total ignorance of the merit of the common law, though its equal at least, and perhaps an improvement on the other. But the principal reason of all that has hindered the introduction of this branch of learning is, that the study of the common law, being banished from hence in the times of popery, had fallen into a quite different channel, and has hitherto been wholly cultivated in another place. But, as this long usage and established custom of ignorance in the laws of the land begin now to be thought unreasonable, and as by this means the merit of those laws will probably be more generally known, we may hope that the method of studying them will soon revert to its ancient course, and the foundations, at least, of that science will be laid in the two universities, without being exclusively confined to the channel which it fell into at the times I have been just describing. For, being then entirely abandoned by the clergy, a few stragglers excepted, the study and practice of it devolved of course into the hands of laymen, who entertained upon their parts a most hearty aversion to the civil law, and made no scruple to profess their contempt, nay, even their ignorance of it, in the most public manner. But still, as the balance of learning was greatly on the side of the clergy, and as the common law was no longer taught, as formerly, in any part of the kingdom, it must have been subjected to many inconveniencies, and perhaps would have been gradually lost and overrun by the civil, a suspicion well justified from the frequent transcripts of Justinian to be met with in Bracton and Flita, had it not been for a particular incident which happened at a very critical time, and contributed greatly to its support.